Welcome to literary and jury charge practice. Let's get started with some jury charge. Ready? Here we go. The jury will decide based upon the facts in the case. The important consideration is the planning. If a killing occurs but there is no planning, then the killing is considered in a different manner. The jury will determine after hearing the evidence whether the definition applies. The jury must find whether the crime is murder. The difference in the verdict will determine how much time the defendant will spend being punished. You may take notes, but your notes are not to leave the jury room. You must consider that your notes may not be correct. When it comes to the killing of a person, not all killing is considered to be murder. Some types of killing may be accidental. Some types of killing may be done in the heat of passion. Killing that is done by accident is different from killing that is done on purpose. In determining how to punish for each crime, the jury will take into consideration whether the crime was planned. It will also take into consideration whether an accident occurred. Certain conditions must exist in order for a crime to be considered murder. These conditions have to be considered. If they do not exist, then the crime is not murder. If the conditions point to an accident, then the punishment is less. You must not consider the punishment. You must reach your verdict without this consideration. You were given a copy of the instructions that you are to use when deciding this case. You must consider the facts. You must decide what the facts are. You must decide what happened based on the evidence that has been presented at trial. You are not to use any other evidence in reaching your verdict. You must consider what happened and reach your verdict without any consideration of punishment. You must consider only the evidence that has been presented. You must not consider whether the person will be punished or not. You must consider what happened when the crime occurred. When the police arrived at the scene of the crime, it was after the crime had been committed. The police did not know what type of crime had been committed. You must consider the evidence that was found at the scene. You must reach your decision based upon this evidence. You must not do any research on your own in making your decision. You must follow the law as I explain it to you. You must follow the law even if you disagree with it. You must follow the law even if you believe that the attorneys disagree with it. You must consider the definition of murder. There is a difference in whether the crime is murder or not. It is important that it be determined whether the crime is murder or not. If you still do not understand the meaning of the term, you may ask to have it further defined to you. You may not use a dictionary on your own. If there is a body, it must be determined whether that body was killed on purpose or not. It is not always easy to determine. It has to do with whether murder was involved. You must use only the evidence that has been presented in this trial. You have been instructed as to the use of notes. You have been instructed not to be influenced by bias. You have been instructed not to be influenced by prejudice. You have been instructed not to be influenced by public opinion. You have been instructed not to let anything influence your decision. As for the question about research, you must not do any research on your own. You are not to use a dictionary. If you need to have a word defined, you have been instructed in that regard. You were instructed not to take a dictionary into the jury room. You must reach your verdict without any consideration for punishment. You must not even consider that punishment may result. Once there is a killing of an individual, it must be determined whether the killing was done on purpose or not. If a killing is done on purpose, then it must be determined whether there was any prior planning of the killing. The key is whether there was any planning involved. It will be up to the witnesses in the trial to present evidence to the jury. You will then decide whether the evidence shows that a murder was committed or not. It may be determined that there was no planning involved. If it happens that someone kills someone in the heat of passion, that is also considered a crime. If someone kills another after planning to do it, it is considered murder. The amount of time that one will be punished will depend upon how the crime is viewed. Some words or phrases used during the trial have legal meanings. All right, now for some more jury charge practice. Ready? Here we go. You must determine whether the witnesses for each side are credible. If you find that they are credible, then you must not count on their testimonies. In doing so, you must keep in mind that there has been testimony stricken from the record. That testimony is not to be considered in your decision. You must not include this testimony when you are making your decision as to the facts in this case. Even if you believe this evidence to be credible evidence, you must act as if you had not heard it. If you have a question with regard to the law, as I indicated, you are to get the bailiff to take the question or questions to me. I will answer your questions as best I can. I will be in my chambers, so I will be here to answer any questions that you may have. You must, however, rely on your own convictions to determine the evidence. There is more than one party involved in the crime. The parties are being tried together. If you find that one is guilty, then you must also find that the others are guilty. They are all principles with regard to the matter. As such, the words plaintiff and defendant apply to each plaintiff and to each defendant, except as you may be instructed with regard to the parties. You must keep in mind that there are two actions that are being tried. Whenever reference is made in these instructions to plaintiff or defendant, such references relates to each party in that capacity. You must keep in mind that the damages is significant. The law that applies in this case determines how to rule in this manner. These individuals have been accused of causing the damage. Your concern is not to speculate with regard to others who are not here. Your concern is to determine whether these individuals acted in a way to cause the plaintiff harm. Whether others were involved is not for you to decide. It is not for you to speculate whether there was anyone else who was at fault. The defendant's attorney has brought that up at trial. That is not important to this case. It is an issue that is meant to confuse you. It is true that others were involved in the accident, but to a lesser amount. However, that is not important to this case. The evidence brought forth regarding this has been stricken from the record. This case is about the evidence and witnesses who are here today. You must determine the result based upon the credibility of this evidence. As I indicated, these persons have only been accused of causing the damage. You have heard the testimony of the witnesses who have testified for both sides. It is now your opportunity to decide whether the plaintiff's attorney proved her case. You have heard the testimony of not only these individuals, but all the others who had evidence to present to the court. After hearing the evidence, it is up to you to decide how to vote. If you have any doubt as to the meaning of the law that I have presented to you today as you try to reach your decision, you may ask the bailiff to deliver the questions that you may have to my chambers. Ladies and gentlemen of the jury, this portion of the trial is when I explain to you your duties. It is your duty to follow the law. You must follow the law, but you must also decide all questions of fact. You must determine from what you have observed whether the credibility lies on the side of the plaintiff or the defendant. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not go out on your own seeking evidence. You must determine whether the evidence presented at trial and the witnesses corroborate the plaintiff's side. Keep in mind that whenever reference is made in these instructions to plaintiff or defendant, such reference relates to each party in that capacity. The order in which the instructions are given has no significance as to their relative importance. Statements of counsel are not evidence. They must not be treated as such. The only thing that is important is the credibility of the witnesses and the evidence that corroborates their stories. All right, the subject of this jury charge is damages. Ready? Here we go. Ladies and gentlemen, the court instructs the jury that just compensation must be determined upon the evidence under the instructions of the court and not upon the statements of counsel outside of the evidence. if any such statements have been made. Furthermore, you are not bound to believe anything to be a fact simply because a witness stated it to be so, provided you believe from all the evidence that such witness is mistaken or has testified falsely as to such fact. The damages, if any, to be awarded to the plaintiff are solely by way of compensation for pecuniary loss suffered by the parents of the deceased. You can allow no damages for pain and suffering of the deceased, nor can you allow any damages for the grief or mental suffering of the parents caused by the death of their son. The test is, in view of all the facts shown by the evidence, what was the probable pecuniary interest of the parents in the continuation of the life of the deceased. Under the law, a probable estimate may be arrived at by taking into account the occupation of the deceased and the income which he enjoyed, his health, age, and the probable duration of life of the survivor, also the talents of the deceased, his habits of industry, his success in life, and the amount of aid in money or services which he was accustomed to furnish to his parents. This estimate you will arrive at from the evidence in the case. The parents had a legal claim upon the deceased for their support, and it is presumed that they suffered some pecuniary loss. The amount of such loss is for the jury to determine. If the plaintiff is entitled to recover in this case, he is entitled to recover, in addition to the pecuniary loss already referred to, the reasonable value of doctor bills, funeral expenses, and all other disbursements paid out as a result of the death. All right, now let's practice some literary. Ready? Here we go. If you feel that when you are through with school, you will improve your life, your attitude towards school may be very different. What is it that school will bring you? If you expect that you will receive good pay, work in a nice environment, have control over your life, have a flexible work schedule, engage in challenging work, and have meaningful responsibilities, you may view school in a positive light. You may view it as the means to achieving the things that you wish in life. It is why you are in court reporting school. Nothing can turn a positive attitude into a negative one faster than stress, yet court reporting school is known for producing stress. Let's examine what produces stress in court reporting school. One research study shows that daily hassles are more likely to have a greater effect on an individual's moods and attitudes than the major misfortunes in life. When you are under stress, you may feel like you have lost control and begin to lose perspective. As a result, you may find your positive attitude turn negative. You may experience just as much stress if you pass a speed test as you do if you fail, depending on how you view stress. It can either motivate you or hold you back. If you look at stress in positive terms, it will motivate you to succeed. If you look at it negatively, it will prevent you from succeeding. Regardless of the source of the stress, if it is chronic and left untreated, it can affect you both physically and mentally. Whether stress is good or bad will determine how you handle the situation. Using a positive approach to the situation will turn bad stress into good stress. If stress is having a negative effect, identify what is causing the stress. Sometimes you have to decide if the problem that is stressing you is real or perceived. Is the situation really a problem, or do you just perceive it as one? Is the situation that is causing you stress something that you can control? If the reason that you are stressed is that you have not been practicing, you have control. Develop a practice plan and follow it. If the reason that you are stressed is something that you cannot control, you have to accept that fact that you do not have control. If you have control over the situation, look for ways to minimize the stress. The way that you react to a stressful situation is up to you. If you find yourself reacting negatively, then change. Start small. The next time you are faced with a minor challenge, decide that you will not let it cause you to feel negative. Practice this process again and again. A way to cope with stress is to find time to participate in physical activity. Take out your frustrations at the gym or by taking a brisk walk. Another way is to talk with friends. Keep yourself in good health. Accept the things you cannot change. If you allow it, stress can get you down and turn your positive outlook in life into a negative one. Don't let stress on the job or at home affect your performance at school. If the stress in your life is chronic, find a way to handle the negative effect on your attitude. Sometimes problems outside of school affect your attitude about school. Identifying these problems and the effect they have on you is the only way you can gain control. Take the example of one student who is having problems at home. Her husband is out of town 5 days each week. Raising the children during the week is up to her. From the moment she walks in the door at night, the children are tugging on her and making demands. She is frustrated because she feels as though she never has time to herself. When she walks into school, each morning she takes out her frustrations on others. She complains if other students make any noise. Let's see what else we have for some literary practice. Let's continue on with something we had already started called God Bless Our Happy Home. I think it's regarding life in a courtroom, working in a courtroom. Ready? Here we go. Wichita doesn't have the exclusive on problems in domestic courtrooms. In our first tour of duty in family court in Denver, we had a gentleman in for contempt for non-payment of support. Now in Denver, many of the courtrooms are equipped with large, heavy wood tables that have glass on top to protect the wood from spills, mostly from water pitchers. In any event, the judge told his respondent that he would have to pay a certain amount of support regardless of his employment situation as it then existed. A recess was called and the judge left the courtroom with the clerk. The respondent rose slowly to his feet, made a fist, and slammed it down on the glass table top, yelling, "I'm not going to pay it." He hit the table so hard that the glass shattered. The act itself seemed to calm the respondent. The sheriff was called and the respondent was ticketed for destruction of court property to add to his other humiliation. Hard to believe he did not break his hand. The table itself was not damaged, but replacing the glass set the respondent back $100. Some domestic cases are just downright uncomfortable for everyone involved. There was a case assigned to us in Denver that involved a couple who were divorcing. The reason for their incompatibility was the wife's sister, who was planning to marry the husband as soon as the divorce was final. Well, you can imagine the line of witnesses who testified about the terrible wrong this man was doing to the family. Most of the scorn was not heaped upon the sister until later in the hearing. The kicker was that there were 3 sisters in the family and all of them were models. All of their friends who testified were models too. Rest assured, we had never seen so much eyeliner and hairspray in our courtroom ever before. You can probably guess that the whole affair dissolved into a cat fight in the hall. We were glad we weren't joining that family for Thanksgiving dinner. Another not so pretty sight was the case where 2 attorneys were calling it quits from their 10-year marriage. The husband was completely out of money, so decided to represent himself. The wife had parents who were so glad their daughter was getting rid of that good-for-nothing that they paid for her lawyer. Of course, the financial situation of these 2 was the worst, absolute worst we had ever seen. It wasn't a matter of who would get the assets, it was a matter of who would get stuck with the most debt. A lawyer representing himself in a case in which he is so emotionally involved is a big mistake. Even worse, this case had so many documents to establish the couple's bills that the case went on and on and on. You know, there were times when the aforementioned water pitchers really would have come in handy. Finally, it was over. The name calling ceased, and at least between the husband and his father-in-law, the debt got divided mostly down the middle, and the wife got to keep the dog. Judge thought about removing the dog from both of them. They were such maladjusted people, but acquiesced and let the wife have it. Poor Bowser. Then there was the case of the surgeon and the homemaker turned real estate mogul, and their very contentious divorce. Besides wrangling over the money and the property in Denver and Aspen, where the accusations that each was an unfit parent, the tension became almost unbearable, and we were more than happy to recess for the day. The wife retired to the fourth-floor restroom and promptly went into an epileptic seizure. Is there a doctor in the house? Sure is. The husband ran into the restroom to help his soon-to-be ex-wife. We were grateful he was there. All right, and on that note, that will conclude our literary and jury charge practice.